Okay, I want to bring in my friend Mark Geragos now. He's a criminal defense attorney, and now he's the co-host of count them, two very popular podcasts, Reasonable Doubt and Two Angry Men. Mark Geragos, since you are the biggest expert I know in famous trials, I wanted to call you about all of these new details that have come out in these court documents after a desert, for 2.5 years, a gag order that's kept us all in the dark. I look at this as the layman and say he's finished. He's absolutely finished. He bought a K-bar knife, a sheath, and a sharpener 8 months before the murder, and then he bought a replacement K-bar knife, or was looking for a replacement K-bar knife and sheath right after the murders, and then you just add all this other stuff on. But what do you think about this massive document dump?
If I'm not mistaken, you and I talked about a while ago, as you said, it's been quite a time period of wandering around in the wilderness. But I think we talked about the fact that if they had a receipt for this knife or this sheath, obviously they didn't find the knife, sometime prior, that would be, as you call it, a bad fact. The one after, the searching after, the way it was phrased and the way it was buried leads me to believe it's not as significant as the purchase before. And why do I say that? I've had cases where prosecutors will argue that somebody went looking for a particular item on the internet, and then when you drill down into it, it turns out that it was just one in a stream of thousands of things that the browser does. So the one after doesn't really do much. If they can tie the sheath or the same kind prior to this, that's definitely going to be front and center of their opening statement and the trial for the prosecution, and the defense is going to have some explanation.
Right. I would also say I did not see a K-bar knife or a knife sheath or a knife sharpener on the manifest when they pulled everything out of his apartment a couple months later. So that's a bad fact, too. Where is that knife and sheath that's identical to the murder weapon and the murder sheath if it's not in your apartment and you just bought it, less than a year ago? So, okay, the other thing I wanted to ask you about is these conditions, these developmental conditions, developmental coordination disorder, obsessive compulsive disorder, and autism. These are the things she's saying make it impossible for him to have been able to run through that house as fast as he would have needed to commit all of those murders, and that this is the one I can't believe. The OCD made him drive around at night, wear gloves. When they arrested him, he was wearing gloves and sorting his trash into little plastic baggies, and change out his shower curtain all the time due to mold. And then the other one was was autism, to say he has a piercing stare and he's strange. So don't judge a book by the cover. It just sounds to me like it's a desperate attempt to find something, anything, to chip away at the bad facts, but it doesn't look like much of a chipper.
Look, there's each one of those taken separately, I think could give you a plausible, it's a circumstantial evidence case. The law on circumstantial evidence in most jurisdictions is if there are two reasonable interpretations, they don't have to be equally reasonable, but two reasonable explanations. One points towards guilt, one towards innocence. You must adopt the one that points towards innocence. The problem, as you've outlined it, if in fact they're going to make those arguments, and I don't know that they necessarily are for each one of those facts. For instance, I'll take one of them out of your litany. The one about gloves and the trash later on, I'm not so sure that that's admissible as a probative fact, and it may be more prejudicial than probative. Why do I say that? That was a long period of time afterwards. If there was nothing in that trash that they found that was incriminating, why would you bring that in other than to just unfairly malign? So I don't know that would necessarily be the one. I'll give you the prosecution argument is going to be, of course, he's going to try and use that for the shower curtain because he was trying to dispose of the shower curtain because the shower curtain was consistent with somebody who wanted to wash off any kind of the remnants of transferred DNA. So that's a tough fact, ultimately, that they're going to have to deal with. But I'll go back to the sheep. There still is, Ashleigh, there have been internet sleuths who have talked repeatedly about whether or not somebody took that sheath from him, and that's the reason you had the fingerprints. So if that does not undercut the theory if they're going to say, yeah, it was mine, but somebody took it and here's who that person is.
Then where's the knife that was bought with the sheath? Like, that's great if you still have the knife, but my sheath was taken and planted with my DNA on that snap. It's just a little far-fetched to say, and I just lost that knife, you know, coincidentally, you know?
No, I think if the defense is going to be that somebody took the knife and sheath, and that is, yes, it's got his DNA, but the reason it's got his DNA because it was his, somebody else took it. We don't know what happened with the knife because they took it. Yes, it was his, but he was not the person who was there. I believe that's got to be, if they've linked this up, assuming everything, that has to be the defense.
Crazy, because the handle of the knife would definitely have more of his DNA on it if someone wanted to plant his evidence at the scene, and the sheath had almost nothing on it. But okay, one last quick question, and I have to make it quick. The defense doesn't want the words psychopath or sociopath used at trial. Okay, state says they weren't planning to. And then the defense wants no inflammatory evidence, like graphic autopsy photos. Well, Mark Geragos, since when does a defendant get to say you're not allowed to show the autopsy photos of a quadruple stabbing? Like, I just can't even imagine you'd ask that question.
Well, let me play devil's advocate here. A lot of times, the victim's family does not want those photos entered into evidence or does not want them displayed in court, or will make the motion or join in the defense motion to just enter into evidence a small number of them for obvious reasons. Nobody wants to be sitting in a courtroom and watch their loved ones' remains be projected and then captured on the internet or paraded around in publications. So I understand that. And by the way, that once again goes to that analysis. Is it more prejudicial than probative?
Well, I think the jury needs to see the horror that this was in order to land upon something like a death penalty. I think they need to know exactly what happened to those 4 kids. That's me. Hey, Mark Geragos, great to have you. Thank you for doing this. I really appreciate it.
You got it, Ashleigh. Thank you.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.